everyone for coming to this Federalist Society event. The Declaration of Independence is not the key interpretive tool to the Constitution. My name is Sam Ellis, and I'm a program director here at the Federalist Society. So thank you again for coming to today's talk. Our speaker today needs no real introduction, but I'll try my best. The Honorable David Porter is a circuit court judge in the Third Circuit Court of Appeals for the United States. He received his undergraduate degree from Grove City College, and he then received his JD from the Antonin Scalia Law School, where he served as notes editor for the George Mason Law Review. Judge Porter then clerked for the Honorable Judge D. Brooks Smith of the Western District of Pennsylvania. And he then served in private practice and has served as the president of the Federalist Society chapter in Pittsburgh since 1995. Without further ado, Judge Porter, please give your remarks.
Well, it's great to be here. Thanks for coming out. I've had a couple of Chicago law clerks in the 4 years I've been on the bench. Julius Kyrie from the class of 18 and Grant, there he is. And they've both been terrific, so I look forward to working with more of you in the future. So the talk is about the allegedly inseparable relationship, according to some, between the Declaration and the Constitution. It's a lively subject, has been for a long time, and for some, the notion that the Declaration has a unique and privileged role in constitutional interpretation is virtually an article of faith. And it seems patriotic, after all. You know, the two documents were signed by founding fathers in the same room, the signing room in Independence Hall. It's right down. So my chambers are in Pittsburgh, but our court sits in Philadelphia. And although the courthouse itself is nothing to write home about, it's like 1975, 70s brutalism. But the location is fantastic. We're a block from Independence Hall, and the Third Circuit's at the top of the courthouse, like the 18th through 20th, 22nd floors, and we look right down on the Liberty Bell and Independence Hall, so it's very inspiring as we do our work. But the documents were both signed there, and it kind of sounds plausible. How could anyone go wrong construing the Constitution in light of the majestic principles of the Declaration? But I'm here to debunk that idea. While the Declaration is a great and consequential document, it's rhetorically powerful. It's come to be regarded over time as a symbolic expression of our national identity. Chesterton said when he visited here, it's the American creed, he said about the Declaration. But it's not constitutional law, and it's not the Rosetta Stone for constitutional interpretation. Like other documents from the Revolutionary era, it might contextualize some constitutional provisions. It might, although you don't normally find the Declaration used this way, it might help to clarify the original public meaning of a word or phrase. But the point is, it's not an independent source of substantive constitutional meaning. So to set the stage, I'll articulate the position of some, and following Lee Strang, Professor Lee Strang, who's done a lot of work in this area, I'll call them declarationists, who insist that the Declaration is the interpretive key to the Constitution, and that they occupy literally all points on the ideological spectrum, far left, far right, and everywhere in between. But for this group, and in the interest of time, I'll just mention a few. In his book, To Secure These Rights, the Declaration of Independence and Constitutional Interpretation, law professor Scott Gerber says the Constitution, quote, should be interpreted in light of the natural rights philosophy of the Declaration of Independence, and the Supreme Court is the institution of American government that should be primarily responsible for identifying and applying that philosophy in American life. George Will, the longtime columnist for the Washington Post, says the Declaration is the master key to properly construing the Constitution's original meaning and continuing purpose. Mr. Will may have borrowed, do we have any Hillsdale grads here? Okay. Mr. Will may have borrowed the master key metaphor from Larry Arnn, the president of Hillsdale College. Dr. Arnn wrote a book called The Founder's Key, the divine and natural connection between the Declaration and the Constitution, and what we risk by losing it. The godfather of declarationism was the late Harry Jaffa. He was Dr. Arnn's teacher and mentor at Claremont McKenna College. He was a political philosopher there, and the founder of the Claremont Institute. Jaffa held that, quote, the purposes of the words of the Constitution must be found in their purest form, not in the Constitution, but in the Declaration, close quote. Jaffa and other declarationists say we know this because, among other reasons, the attestation clause at the end in Article 7 of the Constitution dates the Constitution by reference to both the year of grace and to the year of the country's independence. And this dating format allegedly makes the two documents interconnected and inseparable. And then most recently, a new form of declarationism has appeared in the Common Good Originalism Initiative. Josh Hammer believes the Declaration, quote, commands deep and meaningful significance in constitutional interpretation and ought to imbue the words of the Constitution with meaning and thereby help guide its interpretation, close quote. And he says when there's a reasonably close interpretive question, judges should use the one that's most consistent with the Constitution's overarching telos. And we find that telos in the Declaration and in the Constitution's preamble. So I'll criticize this position in 4 ways. First, it's bad history. Second, the Declaration and the Constitution themselves don't support it. Third, there are textual arguments based on the attestation clause, and another one that I'll come to based in the US Code are easily defeated. And then finally, the Declaration's revolutionary principles aren't justiciable. They're just not susceptible to a judicial decision. So we'll start with history. If the framers drafted the Constitution to codify the natural rights principles of the Declaration, one would expect to find piles of supporting historical evidence. For example, in Farron's records in the Federal Convention, in Madison's notes on the debates in the Federal Convention, in the minutes taken by Hamilton and 3 or 4 other delegates at the convention. But there were just 2 references to the Declaration that summer at the Federal Convention, and not a single delegate to the convention said the proposed Constitution codifies the Declaration or its principles. If the Declarationists' claims were true, one would also expect to find support in the Federalist and in anti-Federalist writings. But throughout the Federalists' 85 essays defending and explaining the proposed Constitution, Publius never suggests that the Declaration is a unique gloss on the Constitution, and in particular, Hamilton's classic discussion of the judiciary in 78-79 doesn't mention the Declaration or recommend adjudication based on its natural law principles. And the same goes for the Anti-Federalists. I think that's significant, given the Anti-Federalists' commitment to republicanism and insistence on a Bill of Rights. The natural rights principles of the Declaration offered plenty of leverage for their arguments if they considered the Declaration relevant to the debate over the meaning of the proposed Constitution, which evidently they didn't because they barely mentioned it. The most complete set of anti-federalist writings we have is Herbert Storing's 7-volume, The Complete Anti-Federalist. It's published here in Chicago. We went through that. Grant actually did this work to see how many references there were. And these are all of the anti-federalist writings that we have. And we found 7 references to the Declaration in those 7 volumes. I think it was 7. Or you could count pretty much on. No, you didn't do Storing. You did.
I did the first set.
I did Storing. I found you could count on one hand the references to the Declaration in Storing's 7-volume work. Grant did the records of the state ratifying conventions, which you would think also would offer support if the Declarationist's position were true. And we found just 7 references to the Declaration in Eliot's debates in the several states' conventions on the adoption of the Constitution. So there's not a whiff of this Declarationist rhetoric in any of the convention records. Professor Jaffa and others have argued that the historical record lacks even a single statement of the framers' intent to incorporate the Declaration into the Constitution because the Declaration's principles were so generally accepted and universally assumed that doing so would have been unnecessary and redundant. That strikes me as question begging, right? But even then, it's unsubstantiated and historically inaccurate. As Pauline Mayer said in her magisterial book on the Declaration, it's probably the best book we have, it's called American Scripture. She said, quote, "During the first 15 years following its adoption, the Declaration of Independence seems to have been all but forgotten, particularly within the United States, except as a means by which Americans announced their separation from Great Britain." I want to take a minute and talk about natural law, because declarationists often lead with the assumption that the American founding was a natural law project, and then lead to the conclusion that, quote, "the Constitution can only be properly understood through the interpretive prism of natural law." That's Josh Hammer. So I agree that some of the founders sometimes made natural law arguments, but it's kind of an important point. Theirs was the modern or Protestant version of natural law that was advanced by continental jurists like Grotius and Samuel Pufendorf and Jean-Jacques Berle-McKee, particularly as mediated through Blackstone, who eschewed scholastic philosophy as unnecessarily complex and unknowable to non-specialists. Blackstone did. Incidentally, in the Declaration, Jefferson's, he substituted pursuit of happiness for property in that trilogy, Life, Liberty, and the Pursuit of Happiness, and he took that from Blackstone, who borrowed it from Berle-McKee. But I mention all this because the scholastic natural law tradition of the common good originalists and some other declarationists is anachronistic. It just doesn't fit comfortably with the worldview of 1776 or 1787. In any event, natural law was just one of many intellectual sources that inspired the founders. Their arguments for independence and fundamental rights and popular sovereignty were also rooted in classical history, in the Bible, in covenant theology, the Scottish Enlightenment, Lockean, of course, in Lockean natural rights, which is not the same thing as natural law, Republican or Whig theory, and English common law. Their primary arguments weren't based on abstract philosophical principles, but on Anglo-American history and constitutionalism, inherited rights from English and prescriptive rights taken from English law and custom. And this became particularly apparent as the country wrestled with the problems generated by the nation's first constitution, the Articles of Confederation. If any document was conjoined with the Declaration and imbued with the Declaration's principles, it was the hapless Articles of Confederation. Both emerged from the same resolution that the Continental Congress passed on July 2nd. But interestingly, the Declarationists never associate those two documents. There's no divine and natural connection between those two documents, even though they were delivered at the same time and, as it were, by the same midwife. So the Articles were eventually replaced by the Constitution, but nobody said that involved instantiating the revolutionary principles of 1776. Because by 1787, the Declaration's plea for independence and focus on international opinion were a distant memory. The framers weren't discussing self-evident truths in Locke's state of nature, before government was established. As participants in the existing American society, their work was more practical. The debates between the Federalists and the Anti-Federalists show that they were driven by prudential and realpolitik concerns like faction, ambition, geography, sectional differences, commercial interests, the nature and exercise of power, and the necessity of compromise. So I want to turn to the documents themselves. The Declaration didn't confer or limit any powers. and it didn't obligate or bind any individual or colony or court or the Continental Congress in any respect. Congress's purpose in publishing it was to lay the foundation for an alliance with France. It was essentially a legal brief appealing to settled English law and the developing law of nations. To appreciate this, look at the heart of the Declaration, the part that does all the work, but that everyone skips over, the 28 charges against the king and the long indictment following the famous preamble that everyone wants to talk about. Those weren't claims, those 28 charges, they weren't claims of natural right. They were English complaints that had been litigated in England. They were inherited by the American colonists after over a century of struggles, Whig struggles against the crown. First and foremost, the Declaration was a foreign policy document. Just days before introducing the resolution calling for independence, Richard Henry Lee wrote, "It's not choice but necessity that calls for independence as the only means by which foreign alliance can be obtained." His resolution, respecting independence, proposed 3 actions: dissolve any connection with Great Britain, form international alliances, and prepare a constitution. It was that last provision that yielded the Articles of Confederation. And then when Congress passed his resolution on July 2nd, I think he offered the resolution around June 7th. Congress passes it on July 2nd, and they appointed, as you know, a committee to write a declaration justifying to interested observers around the world their vote for independence. In the opening sentence of the Declaration, Congress framed its statement in international terms. They said a decent respect to the opinions of mankind requires that we should declare the causes which impel us to separate from Great Britain. Here is Thomas Jefferson's account of what happened. Quote, "When forced to resort to arms for redress, an appeal to the tribunal of the world was deemed proper for a justification. This was the object of the Declaration of Independence." The Declaration was concerned with the right of nations, not individuals, so it has limited utility as a gloss on the Constitution, which mostly concerns internal governance and the relationship between the citizen and the state. The Constitution was written 11 years and ratified 13 years after the Declaration. Think about how long that is in politics. Based on the timing alone, it's a stretch to say the 2 documents are, interconnected and inseparable. I'll just throw this out. Of the 56 men who signed the Declaration, how many do you think signed the Constitution? Any guesses? I think a lot of people probably assume that there's like almost a 1-to-1 overlap. 6 of the 56 signers also signed the Constitution. 11 and 13 years is a long time in that context. If the Constitution codified the Declaration's principles, one would expect it to say that. They were able lawyers, they knew how to incorporate one document into another, but instead, the Supremacy Clause declares this Constitution to be the supreme law of the land, and it commands judges and other officers to give an oath to support this Constitution, not the Declaration or any other document. Nobody voted to make the Declaration binding law or to apply its conception of natural rights as a gloss on the Constitution. So while the Declaration deserves our undiminished devotion, as Jefferson said, because it's a felicitous expression of the American mind, he said, and for a lot of reasons, I don't mean to run down the Declaration, but it's no more part of our constitutional law, that a judge could apply, than is Thomas Paine's Common Sense, or the Articles of Confederation, or the Treaty of Paris that ended the war, or any of the other fundamental testaments of the American Revolution. So we come to the textualist argument, one that the attestation clause is a textual hook for the idea that the Constitution should be read in the spirit of the Declaration. To begin, it just doesn't follow, right? It's a non sequitur to suggest that the date of independence, that a reference to the date of independence somehow proves the framers were importing the Declaration's substantive principles into the Constitution. That's a logical fallacy, I think. But besides that fallacy, there's another historical problem. The convention of drafting attestation clauses using regnal dates, the year that began a sovereign's reign together with the year of grace, wasn't peculiar to the Constitution. It was an ancient practice, starting with the Romans, continuing all the way into modern history. The English used it in their charters for the American colonies. And then when we Americans drafted our constitutions during the prolific constitution-making period of about 1776 to 1790, we included all the same elements from those earlier charters, including the attestation clauses. This same dating convention was used in the Treaty of Paris of 1763, ending the French and Indian War, and in the Treaty of Paris of 1783, ending the War of American Independence. And it was used in diplomatic letters and resolutions of Congress to other nations, and it was used in the Articles of Confederation. Gouverneur Morris drafted the attestation clauses for both the Articles of Confederation and for the Constitution. So it's not surprising that he used the same form. You know, after all, it was just the attestation clause. It's at the very end, right before the signature. So it copied and pasted what he'd done in the Articles. As you know, when interpreting legal documents, we don't assume that the drafters hide elephants in mouse holes, right, as Justice Scalia said. So we shouldn't assume that when the framers used this ancient and conventional dating format in the attestation clause, they were secretly incorporating the entire Declaration as another source of constitutional law. So I mentioned at the outset there's a second sort of textual argument based on the US Code, because declarationists sometimes point out that the Declaration is, after all, included in, quote, the organic laws of the United States of America, close quote, in the US Code. Doesn't that prove that it should be treated as law? It's in the US Code. Well, no, it doesn't. Congress added the Declaration to the US Code in 1926. Together with the Articles of Confederation, would that still be law too? And with the Northwest Ordinance? All of these materials, Congress said, are ancillary to the general and permanent laws of the United States. So it was just a ministerial act undertaken on the 150th birthday of our nation's independence. It was a gesture of respect, and in order to give pride of place to these great documents that helped to shape our nation, but not because they have any continuing legal validity. So I want to make a quick textualist observation, and then I'll move to the last point about justiciability, and we'll wrap it up. The framers memorialized their numerous compromises. Of course, just think back to the summer of 1787. They memorialized their numerous compromises and specified the limits of their agreed upon legislative bargains in the text of what the Supremacy Clause calls this Constitution. Only that text survived the gauntlet of the Federal Convention and then ratification by a supermajority of the states. We shouldn't disrespect that rigorous supermajoritarian lawmaking process by looking beyond the text to the framers and ratifiers' alleged collective purposes, assuming we could even know that. Think about how many ratifiers there were. By construing written provisions to serve abstractions like life, liberty, equality, the pursuit of happiness, declarationists essentially reject textualism in favor of full-blown purposivism. It's exactly what Brutus, the anti-federalist, predicted would happen. He said federal judges would expand their power through equitable construction according to the spirit and reason of the text. Okay, so much for the textualist point. All right, declarationists like to focus on the philosophical language of the preamble. But those aspirations, as Justice Scalia called them, are hardly a blueprint for governance. How could a judge decide constitutional cases by invoking the principles, for example, that all men are created equal or that they have certain inalienable rights? The founders knew how to codify fundamental principles that government must respect. They did it repeatedly in their declarations of rights and bills of rights attached to their state constitutions. In the Federalists, Alexander Hamilton scoffed at the idea of enumerating such rights in the proposed Constitution. Structure, he said, structure would protect our rights, quote, more than volumes of those aphorisms which make the principal figure in several of our state bills of rights, and which would sound much better in a treatise of ethics than in a constitution of government, close quote. It's Federalist 84. So when the Federalists finally consented to the Anti-Federalists' demand for a Bill of Rights, they could have readopted or incorporated the relevant provisions from the Declaration's preamble, but they didn't do that. Why not? Because the mere existence of the Declaration and its natural rights wasn't thought sufficient, right? The framers debated whether the proposed Constitution adequately secured people's rights, but they didn't say that those rights were adequately secured merely because they were natural rights. Instead, the specific provisions of the Constitution and the Bill of Rights were thought necessary to secure the people and their natural rights from the state, or more accurately, from the new national government. So this raises an obvious question. If the framers didn't think it appropriate to use natural law theory when framing the Constitution, why should we assume that they intended federal judges, of all people, to invoke natural law when interpreting it? I want to emphasize that none of this is meant to disparage natural law or natural rights or to deny their existence. I don't think that. It's not my view. But I do agree with Robbie George at Princeton that in our constitutional system, judicial duty requires judges to respect the limits on their authority imposed by positive law. And when they exceed that authority by substituting their own understanding of natural law, they, quote, violate the very natural law in whose name they propose to act, close quote. Even if judges tried to do what the Declarationists urge, just picture the chaos that would ensue. If you think that unenumerated substantive due process rights are a problem, imagine all federal judges, all 800, whatever federal judges, not just the ones that you know and like, applying the Declaration's natural law. Some of my colleagues, right? Imagine all of us applying the Declaration's natural law principles to constitutional claims asserting, for example, rights to abstract equality or the pursuit of happiness. What could possibly go wrong? Okay, that's the end of my talk. So I'm happy to answer questions about that talk or about anything else that you would want to ask. Yes.
Thanks for coming and speaking to us. I'm curious, and I don't want to put you on the spot here, but I'm curious what some of the reasons were for the Declaration of Independence being mentioned even at all in the Federalist Papers and in some of the state constitutions.
They were mentioned for things like for the proposition that a people have a right to get rid of one government and form another. Not contested, not really relevant to this subject. Or to point out that one of the reasons for our revolution and the new Constitution was because King George was taking away the right to a jury trial. Things like that, things that just really weren't contested. Or sometimes it was mentioned to argue either that the new nation was a union or a confederation, an issue that was finally decided by war. But those are the kinds of things where the Declaration was invoked. Yeah.
Thank you for your talk. I guess I was wondering, beyond just the declaration, more as a question of like background natural law, how you would deal with the more narrow claim of, in cases of the Constitution's ambiguity, interpreting it against those background principles. And I think like I could come up with a counter argument that maybe I'd like for you to respond to, which would probably look something like this. So European and English practice throughout centuries, but certainly even in the modern period after Grotius, there is a common habit, not universal, but common, of reading positive law in light of background principles.
Mm-hmm.
So in England, it would be like Somerset's case
Mm-hmm.
and Dr. Bonham's case,
Mm-hmm.
where in most cases the positive law is treated as decisive.
Yeah.
But when we're not sure how it actually applies in this case, whether because of absurdity or language, we look to background principles. And in fact, American private courts and American lawyers, and even the Supreme Court, in cases like Calder v. Spill,
Mm-hmm.
make arguments very similar to this.
Mm-hmm.
Not that in every constitutional case we should appeal to abstract rights, but in cases where we really aren't sure about what the Constitution means, or what a statute means, or what a will means, that we can then give recourse to more established background principles of the law of nations and the law of nature.
I agree. Some of the founders, some of whom then became justices, favored that approach. Justice Story did. James Wilson from Pennsylvania is probably the most ardent natural lawyer among them. But I don't think that approach took hold in our jurisprudence. They tried early on, but I don't see it. Wilson at the convention tried to give judges the power using their moral sense to review laws, but the framers, the delegates, voted that down on 3 separate occasions.
So if I could just ask a follow-up. I mean, so it's interesting that the originalist argument would be after the Constitution, some judges may have done this initially, but over time this practice didn't carry on.
Yeah.
I guess the question is more as a matter of original understanding.
Yeah.
What the established legal culture at that time thought.
Mhm.
And I mean, most of these lawyers, even though Blackstone is, maybe breaking with the scholastic tradition.
Right.
Blackstone
He was a natural lawyer, sure.
Yeah, he's
Yeah.
certainly in the English tradition.
Yeah.
And so I think, like most of the founders and most of the lawyers would at least understood law through a natural law lens.
I don't disagree. I don't know how far one could take that argument, but I don't disagree to a point. Yeah. I think it's a fair point. Yes.
Yeah, I was kind of built on Matt's question a little bit, but I was wondering, to what extent does the Declaration tell us, about the political theorists that were important at the founding, and then the relevance of those political theorists to modern questions? So, for example, like modern scholarship on the non-delegation doctrine in the originalist context kind of challenges the classic originalist citations like Locke in the Second Treatise, where he discusses the blending of executive and legislative power as tyranny, citing some modern historians that say that Locke wasn't particularly influential at the founding, and that his influence was waning. So how does kind of the inclusion of Locke and kind of those ideals in the Declaration tell us something a little bit about maybe the influence of that political theory on the Constitution itself?
Yeah, I think that could work both ways. One of the most aggressive people doing this is Randy Barnett right now, right? And I think his view is that we should use a natural rights interpretation, essentially a Lockean interpretation. But I'm not sure that that's historically accurate. And I'm pretty certain that it's not legally. I mean, in the 14th Amendment debate, I haven't kept entirely up on that. I haven't read everything that's come out the last year or two. But before that, as the debate was taking shape between the sort of enumerated rights position, that Kurt Lash has articulated, or the natural rights position of Barnett and others, I personally think that Kurt Lash has the better of that argument. So does anyone want to talk about the Third Circuit? Yeah.
I have another question about it.
Oh, okay. Yeah. Fine.
So I think one of the more common objections to the originalist enterprise would be that in reality, originalist judges are appealing to principles that are not codified in the text all the time to understand ambiguity. So, Justice Scalia does it with standing doctrine and separation of powers. Justice O'Connor does it in the anti-commandeering doctrine with accountability. In SELA law, the deciding point between Justice Roberts and Justice Kagan is whether we think a single-headed agency or multi-member agency is more like obstructive of arbitrary power. So in other words, it does seem like originalist judges are appealing to principles outside of the text.
Or, right.
Did you see that it's different than appealing to like natural law?
But because I think most of those examples that you gave are appeals to other parts of the structure of the Constitution. So it's not sort of a philosophical principle, an abstract principle. It's coming from other structural aspects of the Constitution. Yeah.
Thanks for coming to talk today. I was just curious, on the Third Circuit, would you say there are like distinctive aspects to the work that you do compared to other circuits?
Well, because Delaware is in our circuit, we get some, we don't get a lot of corporate law cases because those are being handled in Delaware Chancery Court and so on. But we get a lot of patent cases coming up from Delaware. We get a good bit of immigration, which was a surprise. I worked in the Third Circuit all my life. I was a litigator, a commercial litigator in Pittsburgh and all around the country. But I didn't have a good sense for the amount of immigration cases that we get because of, we have immigration facilities in Newark and York, Pennsylvania, and cases coming out of there. Because Philadelphia is Philadelphia, we get some good constitutional cases coming out of that city. The Virgin Islands is part of the Third Circuit, so we have Virgin Islands law that we have to deal with. But it's essentially analogous to federal law, especially on the criminal side, which is mostly what we get out of the Virgin Islands. What do you think? Anything else that really sticks out from our docket?
I mean, procedurally, maybe the difference between writing precedentially and not precedentially.
Well, some of the unique features of the Third Circuit compared to like the Seventh Circuit, which argues a lot of its cases, or the Second Circuit, which argues everything. We only argue cases that the panel wants to argue. So if any one of the judges of the three wants to argue a case, it'll be on the list. We don't even discuss it, let alone debate it. If somebody wants to hear it, it'll get argued. On average, we argue about a third of our cases. And then we don't publish all of our opinions precedentially. Drives the bar crazy. I happen to think the bar's right. I think we should publish nearly everything. But we use a thing called the NPO, non-precedential opinion. So the bar, you can't cite those NPOs back to us. And we don't cite them ourselves, but they do dispose of a case for the parties in that dispute. And we also use the NPOs, I think improperly, as a way to hide our problem children. So if this has happened to me twice in the last year, we have a panel where two judges are going one way and another judge is going to dissent. And it's going to be a precedential opinion, and it's getting messy, and there's a long majority opinion and a long dissent. The decision gets made at some point by the majority we'll just turn this into an NPO. I think we should just duke it out, and let the opinions fly, and then there's a precedent on the books, and even if I'm in the dissent, I won't like that precedent, so I'm bound by it going forward. But I don't like this, hiding things in NPOs. Sometimes when we're on the fence about how to decide a case, we're not entirely agreed, we'll say, we'll just, there seems to be a feeling that if we just make it an NPO, it'll be easier for everyone to sort of come along. So that's the NPO speech. Yes?
Thank you so much for coming. I'm sorry, this is not about the Third Circuit. This is actually harkening back to some of Matt's questions. And I was just wondering about what you think of kind of just an argument as a descriptive matter of judges and justices up until like around 1900 and the onset of the legal realist movement actually not really doing something that resembles same sorts of things that originalist judges argue about today with original public opinion. It's just hard to read an opinion by Justice Marshall, who's so influential in establishing kind of principles of constitutional interpretation and how that works in the United States. Like, how do you reconcile those two things? Or do you think that what he was doing was a form of originalism?
Yeah, I
Just
do.
didn't call it by that.
Yeah,
Okay.
didn't use the language that we now use, but yeah, I
Uh-huh.
think he was doing originalism. Yeah. I think most originalists would say that until, you know, the 20th century, the court was doing originalism. Yes.
I'll ask a question.
Okay.
Oh, sorry.
You're both.
You go.
Thanks, Grant. So I guess this isn't the Third Circuit in particular, but there were the events at Yale Law with the
Yeah.
shutting down, and then there was a subsequent letter. I want to say it was DC Circuit Judge.
Judge Silverman, yeah.
Sent out a letter. I don't know if you can comment on the letter at all, if there's something to be private. What are your thoughts on that? Do you think that we, large part of the judges, when they're selecting for should look at stuff like that, or is that?
I guess I wouldn't presume to tell other judges what to consider when hiring clerks. I mean, I personally, I wouldn't look favorably on an applicant who was doing what those students were doing. But, you know, everyone to his own. It was funny though, I mean, we don't normally get an email from another judge that went to the entire judiciary and then replies to the entire, you know. It was kind of a wild day.
I think we have time for one last question.
Yes.
I'll ask it then.
Okay.
If there's nobody else. So this kind of goes back to the line of questioning on using other non-constitutional principles to interpret the Constitution.
Yeah.
And it kind of presumes that there is a construction zone, that there is a truly ambiguous question. Is that, and when we discuss that, like true ambiguity, it seems almost like an intellectual exercise more than something practical
Yeah.
that we deal with. Do you think there ever are truly ambiguous questions where you would have to explore?
Constitutional questions?
Yeah, we'll say constitutional questions.
I mean, I haven't encountered one yet. I imagine, I'm sure it's possible. You know, ambiguity is part of the language. And the farther away we get from 1787, maybe it would become more likely, but I haven't encountered it yet.
Well, please join me in thanking our great speaker for this.